after y'all move out. The next one will be the Hitchens versus Murrell, rather. We'll wait for the doors to close. Take your time, it's fine. All right, and counsel, how much time would you like for rebuttal?
I'd like to reserve 5 minutes.
Okay.
Thank you, Your Honor. May it please the court, my name is Justin Payne. I represent the appellants Stephen and Selena Hitchens. To give a big picture overview of the oral argument today, there are two basic reasons that the final judgment should be reversed. The first is that the trial court imposed an additional requirement to exercise the right of first refusal that was not in the declaration. The trial court required an actual notice, which is completely contrary to what the declaration states. And even if actual notice was actually required, the evidence on record shows that Hitchens proved actual receipt or actual notice of the right of first refusal exercise. The second big picture issue is the court denied specific performance based on a $5,000 escrow deposit theory that was not pled. This was not escrow deposit as a condition precedent, and it was not denied with any specificity at all, and counsel even admitted that it was not.
That's our case, that Godshall case that says you have to specifically set forth the condition precedent if you're the...
Exactly, Your Honor. Exactly, Your Honor. And
You could ask the guy who just left, he wrote that.
well, that's my exact point, Your Honor. The escrow deposit is a condition precedent. It was not, the condition precedents, we've alleged that the condition precedents were performed or waived. Counsel...
So they had the duty then to say, okay, this is the one that you specifically hasn't complied with.
Exactly.
Under Godshall, and because they didn't do that, then you're saying this whole $5,000 security deposit issue, because you objected at trial, this is kind of a red herring. It's not, should not be part of the consideration.
Exactly, Your Honor. And
the trial court couldn't rule on that because it was not properly before it.
Correct, Your Honor, and it's a fundamental fairness issue because...
Due process.
Yes, exactly, Your Honor, exactly. And even with the $5,000 escrow deposit theory, regardless, Mr. Morrell had already refused the transaction at multiple steps, at every step along the way. Before the notice was done, then he canceled...
Your client.
Yes.
He wanted to sell to Ms.
Correct. Let's see, Mr. Morrell refused the transaction. He told my client, Mr. Hitchens, and he also informed several other people and canceled the contract. Or he attempted to cancel the existing contract. Going to the first issue, the right of first refusal notice, the trial court made specific findings for three things that should have ended the notice issue. Section 17.54 makes the certified mail notice effective on mailing. It's very clear, it's unambiguous in the declaration. The court found that Hitchens' notice clearly exercised the right of first refusal and that it was sent by certified mail on March 29th. That it was sent.
Did it timely within the 10 days of the HOA?
Correct.
Condo Association posting the notice?
That is correct, Your Honor, exactly. At that point, the notice issue should have been resolved. But the court then imposed a fourth requirement, actual receipt. That's not in the declaration. It just simply isn't.
So what do you think of the Maloney versus Atlantic condominium complex case that your opponent seems to like so well?
I was just about to talk about Maloney, Your Honor. That was the basis of the mailbox rule and where all that discussion came from. The Maloney line of cases is clearly distinguishable on the main point, which is that the declaration or contract in Maloney was silent as to the effective date of notice. Our declaration is not silent as to the effective date of notice. Our declaration states that the notice is effective upon mailing. Exact words.
So at that point, your client steps in the shoes of Ms. Farr, I guess?
Exactly, Your Honor. Exactly. It stepped into the shoes of an existing contract.
Mr. Merrill now has a quote-unquote contract with your clients once they executed timely their notice of right of first
Correct, Your Honor. They stepped into an existing contract, which also, the step into the shoes argument, Your Honor, that has implications, Your Honor, that once they stepped into the shoes of an existing contract, essentially the names are replaced. The Hitchens names are replaced. Now, there was also an existing escrow deposit structure and an existing escrow deposit that was deposited. Now, going back to, I jumped around a little bit. Regarding the notice and receipt of mailing, but even under the incorrect standard that was applied, the record shows actual notice. The United States Postal Records, the certified mail records show that it was delivered to an agent on April 1st, let's see. No, I'm sorry, on the day before.
That's neither here nor there, though, is it?
No, but the trial court based a lot of
I know that, but I mean, well, let's assume that Mr. and Mrs. Murrell didn't ever got it. Your point is it doesn't matter whether they did or didn't.
Yes, Your
They
Honor.
may have gotten it, they say they didn't, whether they did or didn't under the condo declaration documents, it doesn't matter.
Precisely, and our fallback position is that even
Got
if,
it anyways, because they were talking about things
Exactly.
anyways.
Exactly,
That
Your
they
Honor.
wouldn't have been able to talk about unless they knew they got the notice,
Precisely.
the intent to exercise the right of first refusal.
precisely, Your Honor. Now, moving on to the escrow deposit defense. This simply was not pled as a defense. Counsel.
And you're saying it was not tried by consent?
No, Your Honor, it was not tried by consent because there was an objection made and arguments fairly extensive at trial, Your Honor, that this was objected to and the basis for the objection was clearly stated. And there was no indication from the court that it was tried by consent. That's not what the court ruled. The court's basis for that ruling in the judgment, it states that we essentially, and I'm paraphrasing, we had to prove that anyway. Hitchens had to prove that anyway, that he paid the escrow deposit, which isn't, I don't agree with. But that was the basis. It wasn't tried by consent. And it's also important that the federal cases that were cited by the Morells are inapplicable because they are option fee cases. You know, this is a very specific type of right of first refusal, and that the cases are different types of options. The federal cases that were cited, they're just simply not on point. Now, the court's ruling that the Hitchens stepped into the shoes of the Farrs under the contract. That comes with ordinary contract doctrine principles that apply also once that determination is made. And it's inappropriate for Murrell to invoke strict performance on one term, the escrow deposit, while refusing the transaction and failing to cooperate with performance and attempting to cancel the underlying deal. With the sum total of the actions by Mr. Morrell, Mr. Morrell cannot on one hand do those things and then turn around and say that Mr. Hitchens has to strictly comply with all the terms, even though for all the things that he's done to, which essentially constitute, it shows that the actions that were done, that it would have been futile for the Hitchens to
They
perform.
never
those
argued that had you come up with the $5,000, we would have changed our mind and gone through with the deal, right?
Absolutely, Your Honor. And the evidence showed that Mr. Hitchens didn't need financing. He had the ability to pay in full, and his testimony was that he could have paid within a day if Mr. Morrell had simply responded or instructed him. There's also,
Or was receptive?
yes, Your Honor, that too. But there was no issue of whether or not he could pay the $5,000 deposit. That was, he clearly could, and I believe the court even found so, or said that it was highly likely, something to that effect, that Mr. Hitchens didn't even need financing because we introduced his bank records. So that was not an issue, and that is a key distinction in a lot of the case law also, is that even if there is repudiation, the plaintiff, or in this case Hitchens, would still have to prove that he could have performed, which we did. And it was, Hitchens proved that he was ready, willing, and able, and that should have been the end of it. The line of cases that discusses this, essentially all the cases together can be boiled down to the rule that the terms of the contract can't be changed. There's some modifications that are permitted because they don't apply to both buyers, but the terms can't be changed to something that would detriment the seller. That's the basic rule. Here, there's nothing that was done to the seller's detriment. He was never in any danger. There was never an unsecured gap of where the escrow deposit did not apply. And that was simply that nothing, Morell's actions caused the only issues. Morell caused the issues that he's complaining of, essentially. Your Honor, I think the case that is most analogous to the present case is Kaplan versus Lafayette. It was and that was, out of all the cases, that is the most closely to all fours that we have. And in that case, Your Honor, Your Honors, there was a right of first refusal. The option, or it was not exercised. There was an issue about informing the buyers by phone and in writing that they were canceling the contract or wouldn't honor it. And the court found that relieved the parties of the escrow deposit requirement. So Kaplan states that the escrow deposit requirement can be waived, or there can be facts that make it futile. And in this case, and that's what we submit has happened in this case.
You don't have to use all your time if you don't want to.
Understood, Your Honor. Then I would like to reserve the rest of my time for rebuttal.
Morning, Your Honors. If it please the Court, my name is Alan Whitehead. I represent the appellee, the Merles, in this transaction.
Counsel, why aren't we into the Maloney case at 1,114, where it's noted that, of course, it's possible in any case for the parties to agree that the mere mailing of the notice shall be sufficient. And then we go to the declaration of condo 17.5.4 that says exactly that. Why? What's left to talk about?
If you look at, and I understand that that's a key issue. If you look at
It's
section,
one of two issues, but yes, it's
Yes, sir.
definitely the key issue.
Yep, it's
don't
one
wanna
of,
axe
one
the dog
of,
here.
at least as it relates to delivery. I think the other issue is more significant and more substantial. But 17.5.4, and in essence, section 17 of the declaration talks about this right of first refusal. And it talks about the need and delivery to either be hand delivery or registered by, or sent by certified mail. The purpose, of course, being to ensure that receipt is affected.
But it was sent by certified mail here.
And it was sent by certified mail.
It was signed for by someone.
No, sir. That's the issue.
There's not a
That was the
signature.
issue of fact. There were 3 items that were sent by certified mail.
All right, so why does it matter whether it was signed by someone in light of 17.5.4's plain language?
Because if you look at the totality of Section 17, and in particular Section 17.5.5, and you read that in conjunction with the Marley case, it talks about receipt and the need for receipt of the document to take action. And that is further followed through in 17.5.5 of the declaration, where it says, in the event that the selling owner receives no notice of any owner exercising the right within 20 days from the date of the posting, the selling owner may then proceed.
That's
So
just
it
between the
presumes-
seller and the buyer, isn't it? I mean, that's an
Right, but it
affidavit from the seller
presumes-
saying, I didn't get any notice, so buyer, don't you worry, right? Isn't that essentially what that says?
It says that the seller can proceed if he doesn't receive notice.
But
the-
as to-
The purpose of the affidavit is to tell the buyer, don't worry, buyer, I never got a notice, so go ahead. You're not spending $100,000 or $400,000, and I got a notice, so you're going to be involved in a lawsuit. The purpose of the affidavit is to say, it's for the seller to tell the buyer, don't worry, I didn't get a notice from anybody, right?
It's also so that the seller can proceed with closing with the buyer if he doesn't receive the notice.
But the exercise of the right of the first refusal is dependent only upon mailing by certified mail, effective upon mailing the notice of intention to exercise the right.
I think a fair reading of that provision is to not say that that is the be-all, end-all of determining whether or not notice was received. It is for the purpose of establishing the date and whether the date of sending the notice meets the requirements of doing it within 10 days. If it's
Again, back to
sent
17
on the
back to
10th, 9th day
17.5.5,
and
counsel.
received on the 15th day, that's what that means.
Council, back to 17.5.5, reading that, says the affidavit from the selling owner delivered at closing stating that he has not received such a notice within this 20-day period shall be conclusive to a purchaser who may rely on same to consummate his sale. So again, it's like I said, it's protection for the purchaser. It has nothing to do with the person trying to exercise the right of first refusal, is it?
Respectfully, I would argue that it is there to protect both the seller and the purchaser. Certainly, the purchaser can rely upon it, move forward, close on the transaction, but the seller can as well, because otherwise he'd be faced with another lawsuit from another side.
So instead of the condo documents saying notice is effective upon receipt, we're going through this,
On mailing.
well, no, I mean, your position is, we didn't get notice because we didn't receive it. Am I misunderstanding what your position is?
No, sir?
Okay, so the condo documents could have simply said, exercise of the notice of the right refusal is effective upon receipt by the seller.
I think it does say that. And,
Well, it
and,
does-
and,
okay.
and I know you don't want to hear it, but I'll explain it if
Well,
you'd
it doesn't
like.
say that. I mean, I've said it fairly plainly. Maybe I could have
sir.
said it plainer, but it certainly doesn't say it as plainly as I'm saying it. You're taking, as obviously my colleagues here are bringing to your attention, it seems like once you send it by certified mail, it's been triggered, and then we'll have another discussion about other issues in the case.
Why do you have to send something by certified mail as opposed to regular
That's
mail?
what the condo documents said.
And why certified mail? Because it ensures receipt and proof of receipt. And without proof of receipt, the certified mail process isn't complete.
You can also
That's
prove
why.
mailing with certified letter. And again, when you go to mail a letter certified, typically the nice clerk at the post office stamps your little white sheet that shows the letter addressed to so-and-so was given to the post office this day for mailing certified mail. So they had that here. They've got proof of mailing, right? I mean, that's not disputed, is it?
No, they did not, what they didn't have was a green card,
I understand
which is
that.
the document. What was presented at trial was the information that actually our side requested and received from the post office documenting what happened, and based upon the three, if you look at the notice that was provided, I think it was exhibit number 4, the certified letter was sent to the association, received by the association.
Didn't the
Sent-
trial judge find that it was sent by certified mail?
The trial judge found it was sent by certified mail.
But you didn't get it, and
We didn't get
there
it.
there was no
And
actual notice,
what-
and that was what the trial judge
What the trial
ran
judge
with.
found was they didn't prove actual receipt of the of
Right,
the
right,
document,
right,
and it was
right.
required to be received.
Well, okay, go ahead.
That, and I understand, I
You're saying
understand
the
your
only place
position.
that is found is in 17.5.5.
Yes, sir. I think if you read this this declaration in conjunction with the case law that we have, I think it does support our position.
Let's assume it doesn't. What do you say about his other argument that the actual security deposit issue has been waived because when they pled conditions preceding generally, which they're permitted to do under, I think it's 1.120C, then to bring it to be a triable issue, you have to specifically respond as to what condition preceding you believe was not met. That wasn't done here. And then under the Godshank case, and I think the Saavedra case that Judge Harris wrote a few years ago, that basically is waived. And if it's waived, then what's the point of talking about the $5,000?
First of all, I don't think it's condition precedent, and we talk about this in our brief. We believe that it's part and parcel of in essence, the mirror image rule as it relates to when you exercise a right of first refusal, you must comply with the terms of the contract, and he failed to comply with the terms of the contract. Paragraph 7, he says, we complied with all the terms of the contract. We denied that in our response. So we talk about this in our
The rules of
answer brief.
procedure require a specifically address which thing was not complied with, if you want to do that. Don't they?
I think it's an element of their case that they must establish.
Yes, they do. He plead, I've met all conditions preceding or they've been waived, and that it's his burden. But as Judge Edwards is correctly pointing out, then 1.120C says, and our case law says, if you don't agree with that there is some condition precedent that hasn't been met, you have to tell the other side as to what it was, so he then, under Godshank, is able to then address that so the trial judge is fully informed. Isn't that what Godshank said?
Yes, sir. I mean, it
Well, why
essentially
is
is, but I think that there's a distinction here because this is a right of first refusal case. And in order to do you must, in order to establish your prima facie case, you must establish that you've done everything called for by the contract. And they didn't do everything called for, not prior to the contract, but by the contract. And that's our position on that. And also we do allege, we don't specifically identify the deposit, but we do allege failure of condition preceding in one of our affirmative defenses, paragraph 45. There are 3 items that they failed to follow that I want to make sure that the panel's aware of. One is the deposit. 2, and it's referenced at paragraph 20 of the final judgment, any even attempt to close, let alone close by April 30th of
Do you expect them to
2021.
go down to a closing agent after your client has said, I'm not selling it to you, I'm not selling it to anybody?
Our
I mean,
client-
Seriously?
The facts, as they laid out, as they were established at trial and found by the court, are as
Did you
follows.
plead that as a specific thing that they did not do? Say, condition preceding you didn't try to close?
No, sir, I didn't say that. We didn't say that in our answer. Okay. The facts as they were laid out was on March 26th, Mr. Hitchens calls Mr. Merle and says, we're considering exercising a right of first refusal. We've seen the contract. Mr. Merle says, I would appreciate it if you didn't do that. I'm selling this at a discounted price to my longstanding tenant. I would hope that you would respectfully honor my wishes. Followed up, same day, by a text communication. That's the sole communication prior to the March 29th exercise. The March 29th exercise is never, the evidence is established, was never received. I know where you stand on that argument, but it was never received by the,
We're not unsympathetic to your client desiring to sell it to somebody who had rented from him for a long time. I mean, we get that, and we get why your client might have set the price below market because of that. But how do you're asking us basically to not look at the condo document very closely.
No, sir, I'm not.
Okay.
I'm asking you to look at it extremely closely.
So let me,
sure?
let me build on what Judge Edwards just said. A reasonable person could conclude that the equities weigh in your client's favor. But if this court determines under 17.5.4 that the exercise of the right of first refusal was engaged at the moment of the certified mailing, do the equities matter? And I don't want to say matter. I don't know that I really love that word. But do the equities allow us to disregard what is plain language in 17.5.4 if that's our conclusion? That's really, for me, the issue.
I'm not sure I know the answer to that question. I think yes, basically because this is an equitable cause of action, certainly for the specific performance component of it. I think that if you, so that's my answer to that. But if I can continue with the timeline just real briefly on because there's I think a point that's being missed and maybe it wasn't adequately briefed, I don't know. But March 29th is the date that this exercise is sent by certified mail. The court found that they failed to establish that it was actually received. Your position, it sounds like, is it doesn't matter because it says certified mail. If you look at how Florida law, and we address this in our brief, treats certified mail and the reason why certified mail is a different type of mailing than regular mail, I think it supports our position. Then we go on to what happens after March 29th, which is nothing.
I mean, this certified mail, if they send it by certified mail and the postman is just evil and says, I'm throwing everything in the garbage today because I don't feel like walking my route, they complied with it. That, yeah, you did. I'll give you, under my scenario, my hypothetical, and don't tell me those aren't the facts of the case because I know I just made them up. But that being, and I'm not saying that directly to you, that's kind of a general rule of thumb around here. That's usually the response, well, that's not the facts of the case. But if my bad postman threw the certified mail out, and so you really didn't get it, your client really didn't get it, how does that matter under the terms of the... I won't take up more. I just throw that at you for thinking. We've already gone around and around on that.
I understand the point.
You can go on to the other issue. I'm just throwing that out. Go ahead.
But let's look at what happened after March 29th. What happens is Mr. Merle and Ms. Farr cancel that contract. But that is not transmitted to the Hitchens. The next thing we hear from the Hitchens in the record is a letter from their lawyer on May 3rd that doesn't say you have repudiated the contract. It's exhibit number 6, plaintiff's exhibit 6. It doesn't say you've repudiated the contract. It doesn't say we tried to close and we didn't. What it says is I represent Mr. Hitchens. I'm writing to reiterate my client's exercise of the right of first refusal to purchase. Please advise, and goes on, says some additional stuff, but then please be advised that my client is ready, willing, and able to make payment of the earnest money deposit and purchase of the property. This is May 3rd, after the closing date called for by the contract of April 30th. There was no attempt to comply with the contract, no claim of a repudiation of the exercise of the right of first refusal that came into evidence. Nothing was done. They totally failed to comply with the requirements of the contract. They tried to modify the contract by requesting an inspection of the property. And let me just check my notes. Are there any other additional questions or any
Not for me.
other points that I can disagree with the panel on?
No. Nope. I think your position's clear.
Yes, sir. I do want to make one point. In the reply brief, there's some discussion, if it's of import to the panel, there's some discussion of a manual of the post office that talks about what certain things say on a return, when you're looking at certified mail and what certain things mean. We don't think the citation has been properly cited, but we looked for and attempted to find those. They were not presented to the trial court. They were not presented in the initial brief. They were not presented at any point in time except the reply brief, and we don't think they should be considered by the panel. We were not able to locate them.
Okay, I won't consider it.
First, in response, Mr. Morrell admitted that he told Mr. Hitchens, or probably told Mr. Hitchens, that he was canceling the contract and with the Morrells. This is on page 1677 of the record. He admitted that specifically. He volunteered that during cross-examination. And that is repudiation. At that point in what
That's
Kaplan...
well before May 3 letter?
Yes. Yes, Your Honor. That was the only time Mr. Morrell also spoke to, or also testified that the only time he talked to Hitchens was during that first phone call before the notice was sent. And then he said that and then later on, he is when he admitted that he probably told Mr. Hitchens that he canceled the contract with the FARS. And that's 1677 in the record. The court actually found that the notice of right of first refusal was effective, and they found that if the notice of right of first refusal was effective, then the cancellation by the Murrells would not have been proper. The court found that. It discussed that in the verbal ruling for the final judgment. So that, even on the trial court's analysis, once you get past the notice issue, the cancellation can't occur. It's an irrevocable option at the point that the FAR contract was originally signed. The right of first refusal turned into an irrevocable option at that point.
Counsel, do you think there's anything about your case that the panel does not understand?
I hope not, Your Honor. That's all I really have, Your Honor, except the request for relief. We request that you remand with instructions to enter a final judgment for specific performance, or fallback position is remand with instructions based on the analysis on escrow and notice.
Thank you very much.
Thank you, Your Honor.
I think we'll take a little short recess now. I think the TV, I don't know if it's totally set up or not, but we'll be back in 5 minutes, so we'll be at ease till then.